Thanks for jumping on. My name is Paul Hitchcock, and really excited for our two guests today. This is Wealth Protector TV, and this is our media channel at Barth Calderon. This is us here in Southern California, and we're an asset protection, estate planning, and business planning firm. And we put on a lot of education like this. And our mantra for years has been to give back value. And so this is a way we do it. And we have clients across the country, about 6,000 clients everywhere, helping them with their planning. Harry Barth is the founder of our firm and the senior managing partner, and is in high demand across the country for education like this. We speak everywhere to many prestigious groups. We put on about 40 to 50 workshops a year, and Harry's our top speaker. So it's going to get a lot of value out of this. Jerry Conrey is the principal and founder of Conrey Insurance and Risk Management, expert in insurance for businesses, properties, a lot more. And so we've been putting on this episode for apartment associations, business owner groups in the last month, and just have had tremendous interest and involvement. So we wanted to roll this out to our big network. And we've got a lot of people coming on board here. And I want to mention as we get into this, that for everybody that shows up, a lot of times there's questions you're going to want to ask about your own planning. So we're going to have Q&A at the end, and you can type your questions in the Q&A along the way too. So if Jerry and or Harry are talking about something, you have a question, put it in there. We want your questions. We're going to address those right here live. And then also we offer everybody a chance to get one-on-one with Harry and Jerry and the team for a complimentary assessment. I'm going to put a link up in the chat for that. If you click on that, you can sign up. You may have questions offline. Those are great. It's one-on-one. We Zoom those. So with that, Harry, let's jump in.
Well, good morning, Paul. Good morning, Jerry. It's good to be here. And we have a lot to talk about in the short period of time that we have together. I've been doing this, and my firm has been doing this. My God, it's close to 50 years now. And so we had the depth of experience is absolutely amazing. And the issues that we're going to talk about today are critical for everyone who's here and for everyone who's not here as well, who will hear the recording later. There's kind of it's kind of the way would I like to put it, a kind of a riddle. The riddle is, who on earth doesn't want to protect their assets? We'll start that way. It's like, who wants to pay more taxes? Nobody. Who doesn't want to protect? Everybody. If we've worked hard, we have some wealth, whether we've earned it, we've inherited, it was gifted to us. I think we want to protect it as best as we possibly can, especially in the environment that we're in. And we're going to talk about that together this morning. So if we don't protect our assets, the default is that we make it easier for creditors and predators to reach our assets and achieve their goals, which are not necessarily lined up with ours. As Jerry will talk to in a little while, sometimes we do have liability. Sometimes it is our fault. Sometimes it's not the other person's fault. Sometimes it's not an overly predatory plaintiff. It's our fault. It's negligence. We didn't mean for it to happen, but things happen. And when that happens, it's all of the work that Jerry and I have done together for you, or people similar to us, makes a difference. It makes a difference in how a case is settled, how to force it to settlement, how quickly it's settled, and a better settlement almost 99% of the time. We've taken the time to evaluate our assets and putting appropriate protection around them. So what is asset protection anyway? Well, I think today it's going to be a 1-2 approach. Jerry is going to be talking about risk transfer. All right. Transferring that liability, not the liability, but helping to deal with that liability to a third party carrier. I'm going to be talking about legal process and legal procedure. But what we have learned, Jerry and I have learned, and this has been absolutely fantastic, and hopefully you'll take away the excitement that we have. When we combine it's all asset protection, both the risk transfer, and the legal procedure, it starts to become amazing and puts our clients in the best position possible. And that's our goal. So today, you're going to get that 1-2, and that 1-2 has been very, very successful. And one of the things, so let's start a little bit about some axioms of asset protection. When I reach the third axiom, my colleague Jerry will jump in and give you a very interesting perspective. So, but what's the first axiom? These axioms apply both for Jerry, for Harry, for our firms, and for you. One does not engage in proper and professional asset protection planning after the event has occurred. We don't have a burning roof on the house and we call Jerry. We don't have enough fire insurance. We don't have that awful automobile crash and call Jerry and say, hey, Jerry, I think we better increase my liability insurance. But it's for some reason or other, get calls all the time. These things happen. Harry, what can you and your firm do to help us protect our assets from the claims of creditors? Although there are things that we can do to help you slow down the process and perhaps achieve a better settlement, there's nothing like preemptory uh, asset protection planning that is done long before any events arise or the facts that give rise to the events arise. So that's number one. Number two, there's a myth floating around out there. It's a real weird myth. I don't know where it comes from, but let me share it with you. And that is your living revocable trust. The trust that we've put together for my family, Jerry for his family, Paul for his family, and most of us for our family are great estate planning tools, avoiding probate, putting down the game plan for the family, getting people in the right positions for legacy planning. But those trusts have zero asset protection characteristics associated with them. So I think we just set that aside because people say to me, well, I have my house in my trust. Is it protected? And the answer is no. If you can reach the assets in your trust, so can a creditor. There are other types of trusts, which we'll learn about today, that do provide asset protection benefits, but not those. And now we get to the third. And the third becomes where Jerry comes to play in just a moment. The third axiom of asset protection is people tell me, I have insurance for that. So I don't know whether or not I need LLCs or corporations or protective trusts. I have insurance for that. I met with someone like Jerry and he sold me a big boatload of insurance and I feel protected. Well, what do you have? Well, I have a $2 million personal umbrella policy. And so I feel that I'm very well protected. And then we say, well, let me ask you a question. Do you believe that that you cannot have a judgment that's in excess of the $2 million? Right? They say, oh, I have 5 million. Do you think you not have a liability in excess of 5 million? So let's understand a few things that we can always have a judgment that's in excess of the insurance that we have. And the art of getting the right amount of insurance, filling in the gaps properly, more importantly, looking at the covenants, conditions, and exceptions that might need different forms of coverage to give us complete that Jerry's going to talk about in a minute. It's not the know all end all. And what if it's punitive, exemplary, or special? It's not covered. So what you really need to do is you really need to, again, have an appropriate, proper insurance program with gaps covered, as well as appropriate and proper legal process. Now, before I get into statistics, Jerry, why don't you talk to us a little bit about, hey, I bought a boatload of insurance, and I have insurance. I'm a landlord, but I have a mold problem. I have personal umbrella liability insurance, but they're trying to get me for punitive damages. Talk to us about this. Talk to us about how that's done. What does it look like, and how do we coordinate this together? Jerry, go for it.
I think that one of the most challenging things right now is our current economy. And because the economy is challenging, I think that what ends up happening is folks look for revenue streams that are different than traditional. And we are seeing a boatload of interesting lawsuits and interesting claims being made these days. And most of it is coming in through regulatory issues and folks hiring a lawyer to act as the attorney general and hold a
PAGA
small
claims,
business
right?
accountable for, I don't know, the stall to the bathroom is 1 inch, not wide enough by 1 inch. So they are suing over that. The reality is that when you look at asset protection and risk management and insurance and the transfer of risk to an insurance policy, it has to fit like hand in glove. Having one without the other leaves you vulnerable. And vulnerability is the very thing that proactive people should be considering, asking the right question. And when you aren't the person best to answer that question, asking that question to an expert, hopefully will open up your eyes and your mind to understanding what you don't understand about risk protection. In this marketplace today, we're very challenged. We have folks who own buildings and lease them to tenants. Tenants get inside and don't pay their rent. Tenants get inside and start to do damage to the inside. And then they are stuck through a very significant process in order to get them evicted. And in the meantime, they're untouchable. And in the meantime, they create new things. They will claim that they were discriminated against, that they were treated poorly, that the facilities were not maintained properly. They'll invent all these ways and things to tie your unit up and to leave them in while there. Then you've got the problem with folks believing that because their home is in a trust, that they don't need to buy a proper level of insurance to protect those assets. And the reality is you need both. Well, the trust is all about what happens after, right? What happens after you're not here, how it transfers. It's really not asset protection in a protection way. LLCs, corporations, limited partnerships. These are the tools that Congress and the state legislatures have given us to protect our assets. But you have to get them in there. And then once in, you have to consider that you're still holding the ball of risk until you transfer that risk to another. The risk of fire, the risk of a water damage loss, the risk of a trip and fall injury, or something much worse. And so a good insurance professional is going to be looking at what's the category of the risk, meaning is it a 5-unit apartment complex or is it a 50-unit apartment complex? Is it a manufacturer or is it a distributor? And we then go and look at what the trends in losses have been, and we keep you advised. And when we get the question of, is it enough? The first question we ask is well, what are you worth? We try to augment protection, but it is not this. There is a misnomer out there that if you buy $1 of insurance, you've protected $1 of assets. I'll let Harry explain how that does not work that way. But the point is that if the insurance policy is significant enough, usually the claim will die at the end of the adjusting process with the insurance company. And so we try to help folks find that balance. And when properly protected through legal maneuvers, you can rest assured that your asset is going to be there to perform the way that you're looking for it to.
Jerry, let me ask you a question. You mentioned a few times, and we're seeing a lot of this as well, regulatory issues, discrimination issues. The bathroom stall is not right. The hot water isn't hot enough. I mean, and of course, tons and tons in California of the wage and hour claims and the private attorney general PAGA claims. So when someone buys a typical personal umbrella policy, or someone buys a packaged landlord tenant policy, or basic business liability policy, I may be wrong, but I don't necessarily think that is the inclusive coverage that deals with those. I think there are other policies for that, right? Aren't there, like offices, directors? Could you explain that a little bit? Because I think that sometimes there are holes, and the holes that are there, sure, our legal structures help protect those holes. But boy, I would sure like to know whether or not we can insure some of them. Tell us about that, Jerry, a little bit, if you could.
insurance has not kept up with legislation. And the industry does not have solutions for risks associated with regulatory. And here's why. Think of it like driving a car. If you get pulled over for a speeding ticket, would you expect your State Farm insurer to pay that ticket for you? No. You don't turn to your auto insurer to pay a regulatory fine because you had not followed the speed limit. It works the same way in the commercial space. If you are expected to provide a facility that is capable of accessibility for those that are disabled, and you have done certain changes to the facility since the law went into effect. And by the way, that law has now been in effect for 26 years. So most buildings have gone through some iteration of change since then. You're responsible for making sure that it is compliant. And when it's not compliant, the legislature has given the ability for the person harmed by your lack of compliance to go after you through this power of the attorney general that their attorney then has. And they've basically weaponized in many ways, shape, or forms. This has become weaponized.
And a lot of weaponization lately.
Yeah, and I'm going to let you explain the weaponization, Harry, because I think you could do it very, very well. But the bottom line is that a well-intended law is now being abused. And it's being abused in the space of property ownership the most and in employee interactions. And so you can get good protection for employee interactions through an employment practices liability policy, but it needs to have a wage and hour rider on it. And lacking that, it's not going to respond to an allegation that you did not treat people properly. So having an insurance professional that understands what you are looking to protect and engaging them the right way, asking them a question or two, is going to expose the concerns that you have and will allow the professional to evolve your protection properly.
Yeah, let me jump on that a little bit and bring that out a little bit further for our audience to understand the dramatic impact of what's going on in America and in California today. So let me give you some statistics and then an explanation of those statistics. So it's kind of mind-boggling, but last year, there were 50 million lawsuits filed in the United States of America. 50 million. So that's, wow, that's quite a number. Now, it's all the regulatory lawsuits, it's all the, contract lawsuits, tort lawsuits, divorce actions, criminal actions, immigration actions, constitutional actions, environmental actions. Every time we ask the legal system to help us, it begins with a complaint. And 50 million lawsuits, that's an awful lot of lawsuits. And then, so that's why most people will have an interaction at some point, or if not more frequently, with the legal system, and it's usually not very pleasant. But there is another couple of statistics, and one of the statistics that I really want to explain very well, and one of them is that 95% of litigation in the world, in the whole world, occurs in the United States of America. And the reason behind that is telling and very important for our conversation today. Wow. Well, I think in general, we do understand we are still the largest economic engine in the world. We have the most businesses. We're a nation under law, so we're going to have more lawsuits than anybody else. Our economy is pretty damn big, and we have a lot of entities. But there's some other things that are interesting. Some characteristics of our legal system, and that is, for example, one, in most places in the world, Jerry, guess what? If I bring a frivolous lawsuit against you, the loser pays. All right? The loser pays. I bring a lawsuit and I can't justify my claims against you. The loser pays. In America, absent contractual change, we have adopted a system that basically says everybody pays their own lawyer. So therefore, I bring a frivolous lawsuit against you, Jerry. It's going to cost you or your insurance company $200,000 or $250,000 to defend. So they pay me $200,000 to shut me up and have me go away. This is not the way in which one shuts down improper or malfeasance lawsuits.
Thank you, Michelle.
2, contingency fees. All right. Started out, like you said, Jerry, as a good idea. Well, legal system's expensive. Uh, so people in the middle classes and others in lower classes that are unable, economic classes that are unable to afford a lawyer, we've adopted a system which was beneficial to them to allow them to partner with a law firm in order to bring a lawsuit so they can get access to our expensive legal system. Of course, you talk about use and abuse. Every mass tort, that you eat too many hamburgers, was there, it's McDonald's fault that you ate too many hamburgers. You drank the water at Camp Lejeune, and it goes on and on and on and on. So at contingency fees and personal injury. So it encourages lawsuits without responsibility. And third, punitive damages. In most countries in the world, there are no punitive damages. And as Jerry will tell you, that pretty much no insurance company covers punitive damage, or it wouldn't be punitive. If Jerry would say if Allstate or State Farm or Travelers was paying the punitive damages, you wouldn't be punished. And the purpose of the rule, and what Jerry was talking about earlier, is that you can have, if the insurance company was paying, you wouldn't have, because the purpose of punitive damage is to change conduct. It turns the jury into a mini legislature, say, this is bad conduct. We don't have a law for this, so we're going to punish you by taking away your assets. So, Jerry, why don't you talk to us a little bit about the interaction of punitive damages and legal fees when it comes to, hey, I was in a bad car crash. It was determined it was my fault. Several people were seriously or critically injured, and they may never, ever recover. I'm going to be sued for an awful lot of money, probably justifiably so. Insurance company, I think, is going to hire a lawyer for me. But then they're saying that I was grossly negligent, and they're asking for punitive damages in the lawsuit as well. Tell us what happens with insurance companies and insurance policies there, if you would, a little bit, so everybody knows. And we're talking about cars, but it could be anything where gross negligence or malfeasance gets involved.
I'll speak to if you're a California resident. If you're a California resident, your insurer, in its language, will actually pay a punitive damages claim. But in the state legislature, it disallows it. So even though the contract says that it will do that, the law prevents it from happening. And now all those forms say, if allowed within the state's regulations. Punitive damages are just what you said. They're designed to send a clear message to others that might be paying attention to this lawsuit to say, you had a duty to act differently prior to this loss arising or this injury arising. And we're not only going to indemnify, not only are we going to hold you accountable for the financial loss associated with the injury or the damage, but we're also going to hit you with a punitive impact to make it clear to everyone else that's in the room that you need to go back and look at your circumstance and correct this issue, because if not, you'll be next. So it was designed to evolve businesses past their current circumstance. All you have to do is go to a third world country and you see how things don't change. And that's part of the charm and why we like to go there. If things don't change, but the reality is that steps that are not consistent in height and tree roots that have uprooted the surface to the point that a person can't navigate it successfully, easily. These kinds of things lead to injury after injury after injury. And in California, especially progressively, we've set up our laws to evolve circumstances beyond their present. But you could also become a victim. And the way you as owners of property can be a victim is when that issue is being weaponized. Somebody who really isn't a patron of yours, doesn't really come to your business very often, but they came looking and searching for one thing you're not doing right, and turning that into a lawsuit that threatens your time away from your objective, which is whatever business it is that you're running. Now, Paul, I think case studies are a good idea for us to talk about. And I feel like we've kind of gotten into the weeds a little bit. The number one thing that everybody wants to know is how do we properly protect our assets? Okay.
Yeah.
And let's just give a typical example. You have a business and somebody gets injured within your property. Okay. There is premises liability protection on most insurance policies that will respond to exactly that kind of a circumstance. But folks, you might wonder, how much is the right amount of insurance? Well, probably 95% of claims are settled within the limits of an insurance policy. But for that other 5%, it is a wake-up call for anyone who has any real assets. That's the moment when they realize that they could be subject to a nuclear verdict of some sort. And when the insurance policy ends, that doesn't stop the other side from looking at what other assets can they liquidate in order to get the rest of their settlement. And that's where, when we started this whole webinar and said, if you've already had the claim, it's too late. You're not going to be able to retroactively add the protection that you need. No one's going to do that for you. So you have to ask that question before the loss arises. You have to have a good conversation with your insurance professional and make sure that you are engaging things properly. But I will tell you, first thing we do is we look at how the property is held.
Hey, let me talk about that, Jerry, a little bit.
Yeah, I mean,
let me jump in there.
Sure.
So, and Jerry will come back on the insurance on that. So let's just use that as a case study and example. We see, which is really surprising to me, but we do see. So, for example, just saw one this week where people have a business, all right, and the business is worth X, but they also own the land and building where that business exists. And the business was appropriately or properly formed, we'll call it at the moment, entity, a corporation, LLC, limited partnership, and the property, which they don't look at as part of the business, was held in their living revocable trust. And what did happen is the liability happened on the premises of the business. It was significant. It was a rape. There was inadequate lighting. There was a lot of security related issues. The business was sued, all right, for failure to have the proper security and precautions, and the property owner was sued as well. Now, the property owner was the living trust, and as we discussed earlier on, the living trust is not an asset protected entity. So therefore, the individuals, the husband and wife that owned the property, were now sued individually to the full extent of their net worth. And even if they had $2 million worth of insurance, and this came back with a $5 million judgment, where's that $3 million going to come from? They could lose their home. And if the business is not structured properly, they could lose their business. They could lose other businesses. They could lose other properties. They could lose other amounts of money they have in their stock brokerage accounts and their bank accounts. And in a few minutes, we'll talk about their retirement plans. But the liability, Jerry, ends with their bankruptcy. So two things should have happened. And then you'll talk about them. One of them is that property should have been held in an appropriately and properly designed LLC. So then just the value of the property itself, the net equity, was the max liability. And second, they should have had insurance to cover those particular types of actions. So why don't you talk about there's two different things? You got the business and you got the property owner. And sometimes they are not the same. Matter of fact, they shouldn't be the same, but the property was held improperly. Had we seen that, we would have corrected that. But let's talk a little bit about that, Jerry.
So there's language in leases that disallows landlords and tenants from being able to subrogate against each other when a loss arises. Nearly every lease has this language in it. A lot of folks never question what they're signing there. But to explain it, that legal document says that if the person was on property and they were injured while on property, and they were there as a guest of the operation or the business, then the only insurance that that person can go after is that of the tenant. Legally, the landlord cannot go after the tenant to get indemnification. But when you do that, landlords, you put this language into your lease, you've now obligated yourself to insure. You've now obligated yourself to have proper protection because you can no longer go to your tenant's insurance for indemnity. So what do? We look for the value of the assets, and we make sure that the coverage is adequate for that. And then we also consider, what kind of an operation is it? You know, is it a restaurant? So you've got the exposure of people eating and dining on site, getting in and out of their cars, walking through a parking lot? Or is it a fast food place that has a children's playground in it? You know, it's the same classification, but look at the differential in the risk. Then, what if it is a bouncy house place, you know, where the kids go and jump on trampolines? There's so many more ways that an injury could arise. So you have to be smart when you're signing these leases and having the expectation of coverage from your tenant. Don't just boilerplate this stuff. You have to think about the risk that is involved. Who are you leasing to, and what is the typical operation that they're doing? And then, is it more hazardous than others? And if it is, then you should seek out advice to determine what the coverage amount should be before you offer that lease in its final form. Bottom line is that you could create lots of ways of liability. You could do it through a contract. You could do it through your verbal discussion. And it could also be a physical circumstance that led to a hazard that led to a loss. You have to think about all these things, whether it's a property imperiled by things like fire, water intrusion, water damage from the inside, theft, vandalism. Everybody thinks about the property first, but the reality is that where assets are truly exposed is on the liability side, and not enough people ask the right questions on that side.
Super,
Harry,
Jerry. Thank you.
do the legal entities like the LLCs get broken apart in a lawsuit if they're not done right?
The answer to the question, that's a very, very, very good question. And there are two components to that. The first to understand is that our legal system really doesn't like, as you're talking about piercing the veil, you know, getting out of the LLC and getting to the individual owners when they have built the protection. The legal system works very, very hard not to do that. Judges do not like to do that. So if you have an entity and it's run properly, and the key is running properly, then more likely than not, the entity will hold up. Of course, that begs the question, and you know that gets to structuring, and we'll talk about that in the few minutes that we have left. And that, you know, if one has three pieces of property, and Jerry's going to talk about this as well, you have three pieces of property. Each piece of property is a commercial building, and let's say each commercial building has net equity of $1 million in it. So we got three buildings, and what we have also seen is that people create an LLC, you know, one LLC to hold the three pieces of property. Let's just analyze that for a second. Now we have a liability at property number one. So property number one, they now sue the landlord. The landlord is the LLC. The landlord's equity, or the value of that landlord, is $3 million. They take down property A, property B, and property C. And not only did we make the landlord a $3 million landlord, we also have three different properties, three different sets of guests and invitees and workers and tenants. So we have triple the amount of risk against a larger amount of equity. Now, Jerry and I look at that and say, we don't quite understand. What did you save? Would it have been better if each one of those properties were in its own LLC? Yes, you would have saved $800, $1,000 a year, tax deductible, and the formation one time of those entities. You would have saved a few $1,000, but you've jeopardized everything that you have in that portfolio. That is absolutely nuts. So So Jerry, and I'm going to talk about the reverse liability associated with that. People, if I see that as their attorney, I will immediately split that into three components. So to get that segregation and diversification, it's nonsense not to have that done. And my job as the lawyer to make sure that my client understands that the dollars spent in doing that are well justified. But how do you ensure that before they say, well, I have an insurance policy that covers, for the LLC that covers the three buildings. And Harry, if you split that into three, what do I have to deal with Jerry, my insurance guy, and what is it going to cost me, and how do I deal with that? So could you please answer? That's a very big question that we see all the time. And Jerry, you're an expert on this, so go for it.
There are times when the right thing to do is to write a separate policy at each location. And then there are times when you can aggregate those risks into one policy because you have common ownership. What you save in the aggregated policy with common ownership is usually a few $1,000s. It depends on how many we're talking about, but you might save a few $1,000s because there's only one policy being issued, and the insurer, as you say. But there's some other advantages too. In the property world, you can schedule all these locations and then blanket them so that you have the value of the entire policy's protection for any one loss, no matter where that loss arises. So there are reasons and whys you do things, but you need to make sure that you are also, the scales, that you're also considering the flip side of it. What's the flip side? Well, what happens when you have a loss at location 2? That's going to now impact the premium of location 1 and 3 as well. Right. So when you silo, then the only policy affected is the one that paid the claim. None of the other policies are even aware that that claim arose. And so you do have to think about these things and weigh them in the proper way. Now, one of the things that I do well for folks with large portfolios is, let's say they have 12 locations and only one has had a loss. When I reverse engineer it and take it out of that aggregated policy and put them into their own, because the other 11 are paying much higher premium as a result of the loss at location 12, we can get an underwriter to recognize that the risk that we've brought them does not include the location that had the losses.
Oh, that's really smart. Yeah.
So, but if we don't take the time to show them that, they will just look at the loss ratio and they will rate accordingly. So it does matter who you have representing you, that they've got enough experience and ability to engage the underwriters in the right way. And then you can get the best of all worlds. But we look at it as like this. We have a big box of tools, and we utilize those tools differently because each risk is different. But anybody that's out there cookie cuttering, and I will tell you right now, you go online and try to rate insurance for yourself, you're 100% in a cookie cutter environment. There's nothing customized in that at all. And more people are believing that consumers can go out and engage and pick the right protection for themselves. And I will tell you, I don't know how they do it, because even with 35 years of experience, I am still running into situations I've never seen before. And so I don't know how a consumer could believe that they could do that on their own. So if you are a property owner because you're here, you need to be asking your insurance broker the right questions. And when we're done today, we'll send a follow-up with some of the right questions to be asking, so that you're empowered to do it. But if you want to ask somebody else to look at things more forensically, and not get the brush aside, well, give us a call. We're happy to do that comparison for you and to help you really get an objective review.
Thank you, Jerry.
Can I ask you quick questions? Because these insurance companies are pulling out of areas, California, Florida, because of these things, for building owners, businesses. Jerry, how has it become more challenging in this landscape? And what are you telling people that are losing their insurance?
Well, let me talk to the people that aren't losing insurance first. If you get a renewal offer, you're already ahead of the boat for about 30% of the marketplace right now is being disrupted. So you're one of the lucky 7. So before you start thinking that you're going to start picking up the phone and calling and getting a bunch of quotes from other brokers and agents, be thoughtful about the circumstance. Since 2019, I'm going to go the year before COVID. Since 2019, the cost of construction in the state of California alone is up 48% since 2019. And that's all in material and labor. So the first thing you should be doing is thinking to yourself, well, what does that mean for me? It means that the amount of protection you have on the premise needs to be increased. The cost to replace your furnishings and fixtures is up 41% since 2019. So if you keep renewing your policies with the same protection or just allowing the insurer to add their 3% roll on, you're well underinsured right now.
Interesting.
You cannot go out and buy today what you did in 2019 or 20. The numbers just, and you know this by going to the grocery store. You know this by walking into a restaurant. So you have to be thinking in a reverse engineering mindset. Do I have adequate protection? And is the time for me to know that now or after the loss? Of course it's now, because there's nothing you could do about it after the loss.
Got it. Got it. So let me jump in before we jump to a Q&A a little bit and talk about. So when we talk about asset protection, I want to make it very clear that there are a lot of things to insure. People want to protect their homes. It's a big asset. How do we protect our homes? How do we protect the inheritance that we may or may not receive from our parents? How do we protect the cash values in our life insurance? How do we protect our brokerage accounts and our bank accounts? How do we protect our retirement plans? There are holes in retirement plans that have to be looked at. Is our businesses structured in the best form for asset protection? Are the properties we own held in the best way? What about our Bitcoin? What about our gold? What about all of those issues? How could they best be protected? So we have a whole cornucopia of assets that need to be looked at that are valuable assets. You've worked so hard to get them, you need to protect them. So here is kind of the proposition that Jerry and I are bringing out. We are able to offer to all of you a survey, a look, an analysis where we take a look at what you have from a legal sufficient point of view, and Jerry and his team look at what you have from a risk transfer and insurance point of view. And then we coordinate with each other. Ladies and gentlemen, that is a slam dunk. Why would you not? You may have the best people in the world as far as you're concerned, but a great second opinion validating where you're at should make you sleep better at night, or we'll be able to find the things that can help you sleep better at night. And Paul will be following up with each and every one of you to make sure that you have the opportunity to do that. And given the time that we have, it's now 9:45, Paul. Let's open up the door for questions and answers. If people have any questions, and hopefully we have some answers. So go for it, Paul.
Yeah, so please type in your questions. I got a couple here coming in. So Harry, you mentioned home. LLC is not for a home. Is that right? How do you protect a
that is
home?
correct. An LLC is basically a worthless asset protection tool for a home. It's fine for rental properties, commercial properties, in some situations for second homes, but not for a home. For a home, we have different ways of dealing with it, with ways of removing equity, changing the ownership of homes. We have something called a residential shield, a trust, qualified personal residence trust, and other things that people also have to recognize. Orange County, LA County, San Diego County, right now they're sitting with a $700,000 homestead exemption. So it's the excess above that and their mortgage. So, but an LLC, you can't just, form an LLC, throw your home in an LLC. And if you do, you also run the risk of possibly losing your capital gains exclusion, risk losing the $700,000 homestead exemption. Not good for a house. House is a special asset.
Excellent. And
there's another reason.
Yeah.
There's another reason, and that is that when you have a personal home, your resident, I'm going to say it the right way, your residence. When you have your residence in anything other than a trust or your individual name, the policy language doesn't equate properly. It talks him and her, they, not it. And because of that, you'll see folks try to solve this by putting the policy in the name of the individual and then naming the trust as an additional insured or the LLC as an additional insured. And I'm going to tell you right now, that's not right. And it won't do what you think it will. So if you have a scenario in which that is your circumstance, you need to reach out right away and get that fixed. And that's a fix on Harry's side because the ownership is the causation of the issue. So again, if you have questions about whether or not you're protected right, give us a holler. But how can you test it yourself? Very simply put, just consider if you were the victim. If you were the victim of a this or that, what would be your expectation of the landlord, of the tenant, of the operation or the business that you're looking at? What would be your reaction to an injury or to damage to your property? You need to think in that mindset to reverse engineer the exposures.
Super.
And then just realize that you're going to be far more liberal about that in your mind than the reality. Because again, go right back to what we talked about with the PAGA claims. There are people out there weaponizing the law in order to just profit from it. And yeah, go ahead.
Oh, yeah, sorry, because this is popping up here. How to avoid due on sale clause of the loans when you transfer into a Wyoming LLC or other entities?
Yeah, I'll deal with that. So 98% of the time it's a non-issue. Because you really, what we found from the vast majority of lenders, the two reasons for that. One, you're not really changing the ownership. You're changing the ownership into the LLC, but you're owning the LLC. So most lenders don't care. Second of all, it makes the equity in that property more secure for the lender. So it's in the lender's best interest that it's done that way. Matter of fact, more on commercial level, they require you to put property in an LLC just to protect it from other people coming in to protect their equity. So we have had on occasion, you have an unscrupulous lender or bank that it starts to rattle the sabers about that. And when we finish talking to them, we're kind of batting 1,000. They kind of walk away. Maybe sometimes they have a little what they call fee for their paperwork, but not much more than that. And should they begin to pursue that greatly, we have some alternatives that could still provide us with asset protection without running afoul of that. But we haven't seen that very frequently at all. We've heard of it, but haven't seen it very frequently in practice.
Now, both of you might want to chime in here, and Harry, maybe start with you. But you're a Vistage member, Harry. You're a Vistage speaker, have been for years. A lot of our clients are Vistage members and people who own businesses. Vistage is a CEO peer advisory group. But so they own businesses, small, medium, and large. And great question has come up here because a lot of those are closely held business owners and families involved, business partners. And the question is, in a closely held or family-owned business, what is the first action or conversation to have with insurance agent and or attorneys to ensure assets are protected?
Well,
there's an art to that, right?
Yeah, there's definitely an art to that, but it's also an open-ended question that does not have an appropriate, it's too general, meaning that what assets? The assets of the owner of the business or the assets of the business? So if the liability is coming up to the business, we look at all the business, their receivables, their machines, their intellectual property, it may own, may own a piece of real estate. So if the assets of the business, and then the other asset protection is that liability to the owner, how do we protect the business from being lost from if Jerry has stock in Jerry Co. and he owns 100%, and then I have a liability against Jerry, I could get the stock in Jerry Co. So how do we protect that from happening? So you have asset protection for the owners of the business, and sometimes in family-owned, closely held businesses, we have sometimes intergenerational ownership of the business. So we have a outside in, an upward down, and a down inside out, inside liability that has to be analyzed from both sides to answer that question.
Yeah, and it's interesting because I think part of this question too is how do you get started? And I know Harry and Jerry, you've got the same procedure.
Analysis,
is you can't bang this out on a phone call. There's a review. I know at Barth, we've got a very tight review process, and it's taken a look at all the pieces. And Harry, do you want to mention that? And Jerry too, how you do
Yeah,
the
well,
review
you just
before you
mentioned
get
it.
to
We have a
conclusions?
very comprehensive review at Barth Calderon, but Jerry has also, I'm sure, a very comprehensive. Why don't you talk us about it, Jerry? What would you want to look at in scenarios like that?
Well, the first thing we do is we through conversation and in prep for the first meeting is find out what one has, right? So we can be somewhat knowledgeable when we jump on the call as to like situational analysis. So for us, if somebody picks up the phone and calls us, our ask is provide us a copy of your current insurance policy so that we can see what it looks like, how it's vested, and what it's providing. And then we will look at if it's an income property, we'll look at things like a rent roll. We'll understand what the levels of vacancy are, what kind of tenancies are involved, because tenancies matter. It really matters. If it is a large manufacturing firm, well, you better have language in there about pollution, and then you should be insuring against it because you're going to be liable no matter what as the property owner. And by the way, they can come back in a lot of states 25 and 30 years later. 25 and 30 years after you've transferred the property, they can come back because when they finally did a core, they realized that there was poisoning of the terroir happening at the time that you owned it. So you become contributory in that exposure. So we opened up with looking at current insurance. We will, before we get on the phone with you, we'll go and look at every one of those locations, gather as much data about the properties that we can via our resources. And then we engage in questions and answers about how it's being held. And by the way, this is the thing that happens every time we have one of these conversations, Harry. I don't know, probably you the same. No one ever asks me that. No one's ever asked me that question. And yet that question appears on every single application. Every single application. So what does that mean? It means that whoever it is that you're currently working with made an assumption and didn't bother asking the question. But who ends up holding the bag?
You do.
The policyholder. The language of the contract says that the policyholder is the person responsible for any misrepresentation, whether intentional or not.
Got it. Paul, other questions?
No, we're good for now. I
We're
want to
good.
say,
Then we are good. And
oh, wait, hang on. We may got one quick one. Maybe we'll take one more. With your asset protection strategies, can you avoid California property tax reassessments when you transfer titles into the entities?
absolutely yes. There will be no reassessment.
So the answer is yes, coming from Harry. And
Emphatically yes.
yeah, encourage you to, I'm going to send out the recording to everybody that signed up, so you'll get it with an opportunity to meet up with Jerry and Harry. So I want to make sure, answer that. Thank you, experts. Thank you, everybody, for listening. Look
Thank
for
you,
the
Paul.
replay
Good
in a
to see
few
you,
days.
Jerry. Thanks,
Yeah.
everybody. Take care. Bye-bye.
All right.